Welcome to the school committee meeting of February 10th, 2014. As we start all meetings, I'd ask you to please join me in a moment of silence. Thank you. I would also ask you to join me in the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Again, thank you all for coming. This is probably a record thing. I guess we had the two biggest town meetings in history of the town of Hanson, and now we probably have the biggest school committee meeting in the history of the town of Hanson. So thank you all for coming. I know this is an important subject, and it's going to be very near and dear to everyone. So I ask you and remind you that we are here this evening to talk about the two votes that were taken. We're not here to re-go over what school buildings or what options are done. This is why there's an agenda for the meeting. And if you notice, there is no open discussion in this meeting. The reason for that is the Attorney General has changed the meeting law for open discussion, and the reasoning for that is you have to stay to the agenda. So if we stray from the agenda, you might hear me asking you to please stay on the agenda, please stay on point with what we're talking about. And if everybody's going to have a chance to have a question and get answered, we'd like everybody to try and be as polite as they can so everybody can come out of this meeting on the same page. We don't want any more confusion. We want complete and utter on the same page type jurisdiction when we leave this meeting. So having said that, we have a full school committee here this evening, missing one member. We have Whitman members and Hanson members. There are 10 of us, 6 from Whitman and 4 from Hanson, and that's a full membership. We have partial Board of Selectmen here this evening, and we have a partial Finance Committee this evening. We also have the town manager. We also have Mark Rich and Jeff Blake from Copeland and Page. They will be explaining to you the sections of the law that discuss town meeting vote and what the vote goes on and how it proceeds forward on town meeting. Hopefully, after that is done, and they're going to be on in a minute, we'll be able to give you some sort of a snapshot of what we're going to do moving forward and how we're going to move forward with this vote or what's going to happen next. Because it appears to me there's some gray areas and there's already been 2 votes. And we want everybody to come out of this room on the same page as to what's going to happen next. So if there is any gray area, please do not hesitate to ask a question, because truthfully that's what we would like to see. There is no theories going on. Everybody has been more than upfront and out in the open with this, so it's been a long time coming. Without any further ado, I'd like to let the attorneys take over. Mark, Jeff?
Can you, yeah, I guess you can't hear me. Hi, my name is a lot of you probably know, my name is Jeffrey Blake, and I'm with Town Council Copeland and Page. And I agree with Bob that we really need to move forward, but of course, and unfortunately, before we go forward, we need to go back. And what I want to try to do is I want to, rather than get bogged down in a lot of the legal language of the different statutes, I want to give you a broad overview, and then of course as questions come up we can maybe get into the statute a little deeper. As we go forward, we got to understand that there are 3 different authorities that we have to abide by in order to go forward. We have the regional school statute, which is Chapter 71. We have the Whitman-Hanson Regional School Agreement, and then we have the debt exclusion statute, because any borrowing would have been subject to or contingent upon a debt exclusion, which is Chapter 59, Section 21. So under the normal procedure, what happens is the school district votes by 2/3 to authorize a borrowing. Under the statute, that authorization, after they make their 2/3 vote, they then have 7 days to notify each member town in writing of the borrowing. Once they send that to the member towns have an option of, under the statute, they have an option of either holding a town meeting or not. They can let 60 days expire, and it's automatically approved. However, under the agreement in this case, with respect to a capital expenditure of one of your elementary schools, the town that was affected must hold a town meeting to get approval for that capital expenditure. And that approval is, it doesn't have in your agreement any two-thirds or majority, no quantum of vote. So it's been interpreted, and I think it's well established that the approval of town meeting in those circumstances would be a majority vote. Under the statute, as you may recall, I said that a town may hold a town meeting. Again, under the statute, it says that a majority of the voters approve it. So once approved, contingent upon, in this case or in other cases, a debt exclusion, the next step would be for the appointing, strike that, the appropriating authority under Chapter 59, Section 21C to vote by a two-thirds vote to send it to a ballot. All right? So that's how the normal procedure should go. What happened here was that the school committee made their vote to authorize the borrowing. Instead of sending notice to both member towns, now understand that while it is a regional school it was a regional borrowing, I think everybody was under the impression that it was really a borrowing by the town of Hanson, since Hanson was the one that was required to do all of the paying and the voting, and it was both elementary schools were in the town of Hanson only. So what the district was required to do was to send two written notices, one to Whitman, one to Hanson. They didn't. Only one went to Hanson. Then the Board of Selectmen were to hold a hearing, strike that, the town was to hold a hearing under the agreement. They did. A majority of the people voted in favor of the article. However, because we were under the impression that it was a borrowing of the town, a two-thirds majority was what we thought should have carried the day, and therefore it was declared that it failed, when in reality it actually passed. So because we thought it failed, the Board of Selectmen then never took that next step to go forward with a two-thirds vote to send it off to the ballot for a debt exclusion. So that's where we sit right now. As it sits, the article, because of the failure to notify Whitman, is null and void, if you will. How do we go forward if, in fact, the town decides it wants to go forward? The way forward would be for the school committee to again vote two-thirds to authorize a borrowing, to notify both towns in writing, and at that point, the Board of Selectmen for the town of Hanson, and I suppose Whitman could if they wanted to, but for the town of Hanson would have the option of either holding another town meeting or not. Now, I think you recall that I told you under the agreement they're required to hold a town meeting. However, because they have already held two town meetings, and at both of them there was a majority vote, that requirement has already been fulfilled. So if the school committee...
Ladies and gentlemen, ladies and gentlemen, please listen to the speaker. We'll have plenty of time to speak as we're moving on. And Jeff, just to interrupt you, this meeting is being recorded and also televised live, so if anyone is out there and listening, please keep that in mind. Thank you. Go ahead.
Well, if I could...
I know this isn't a town meeting. My name's Richard Hickey. I live at 43 Morton Street.
Oh, he's not finished talking.
Sir, you have to wait till I recognize you. I'm the chair of this committee, so
Thank
please...
you. My name's Richard Hickey. I live at 43 Morton Street. Please, I'd like to speak to Attorney Blake
You'll
directly.
have that opportunity the second he's finished, and then everybody will be on the same page. They'll all have the same opportunity.
Okay,
to speak.
I
You
think
will- you will
subsequent to
have that
hearing me,
opportunity.
it may shorten this a little bit.
Please let him finish.
Sure.
Thank you.
All right. I believe where I was that the school committee would revote, get two-thirds, notice both towns in writing, and at that point, the Board of Selectmen would have the option of holding another town meeting or not. After the expiration of 60 days, the article would be, the borrowing would be approved. Now, I guess I need to back up a little bit. The regional school district would vote to authorize the borrowing contingent upon a debt exclusion. So once it went to the Board of Selectmen, they have the option of holding another town meeting. And if they did, then I suppose they would have to wait to see what the outcome of that was. But if they didn't, then they could, by a two-thirds vote, send it to the ballot for the debt exclusion.
Now, do you have a question, sir? Thank you for your patience. I'm just trying to keep some resemblance of order here, so thank you very,
that, Mr.
very
Hayes.
much.
Thank you.
Thank you. I
that very
appreciate it
much.
from you, too.
Mr. Blake, my name is Richard Hickey. I live at 43 Morton Street in Hanson. If I understood you correctly, what you indicated was that the school committee made a procedural error from the beginning. If in fact that is, let's just say that's conceded, and that error was made, this entire process has to start over. 5921C, 5921C, subsection K, permits the town of Hanson, the citizens of Hanson, to have a vote. The Board of Selectmen will not have the option of stating to the members of the citizens of Hanson, the school committee made a procedural error at the beginning of this process, and subsequent to that, on representation by town council, who is the responsibility to represent us as citizens and taxpayers, has let those procedural errors occur, okay? And under the rules of professional conduct, you know those are irrefrangible canons. You do not have the option of privilege of saying, my bad on something, and we're going to move forward. You do not. Rule 1.1 and Rule 1.3 are very specific in that regard. So we have to start this entire process from the beginning. I will concede that errors were made. Errors were made, and you were in error, sir, for not picking up on it at the beginning. That's what we pay you for. You should have been on this from the beginning. Okay? Copeland and Page has been doing business with our town and a lot of municipalities very effectively for many decades. We trust in you. We place trust in you. It is your responsibility not to be wrong. You do not have that privilege. In the preamble on the rules of, I don't have to read them to you, you're both attorneys. The very first sentence.
Mr. Chairman,
You're
if
a
I may-
public citizen.
Mr. Chairman,
You have an obligation to us.
Mr. Chairman, Mr. Chairman,
Yes, Mark.
I think we've heard the point. I don't know how much more.
I was looking for the question, sir.
That's exactly what I was
Well,
going to ask.
my
for, Mr.
question is,
Chairman.
if in fact procedural errors were made by the school committee initially, let's just say we all concede that, I do not understand how any vote we made as citizens of Hanson subsequent to that can be held now as considered valid when the process was wrong to begin with. We were misrepresented from the beginning.
Okay,
That
so-
error should have been picked up on immediately.
That's your question. Do you understand that question, Mark?
Yes, Mr. Chairman,
Okay.
if I may, Mark Rich from Coleman
ahead.
and Page. I appreciate the speaker's comments and the point that's being made. I think what we're attempting here today is to outline a number of issues that have occurred at this meeting from the start and going forward. What Attorney Blake attempted to do is go through the various authorities that we're dealing with, both the statutory authority, regional school district agreement authority, town meeting authority. These are very separate and distinct matters. The regional school district agreement differs from the requirements of Chapter 71, Section 16. Chapter 71, Section 16 does, and I will grant you, require that both towns be notified in order for the debt, if I may,
Well, 7116D is aid from state. That's not.
If I may, sir, if I may.
Let him finish. Let him finish,
I appreciate
please.
that. If I recall correctly, did you say you're an attorney?
You can finish.
Did you say you're an attorney?
I did not.
Thank you. So I appreciate just the courtesy of my legal interpretation. Again, Chapter 71, Section 16, small d, dictates the process for the incurring of debt by a regional school district. And it does require that once the debt is voted by the school district, that both towns be notified within 7 days. And that then triggers the ability of the Board of Selectmen to send the matter to town meeting within 60 days or not.
Agreed.
Should they choose? Sir, if I may. I'm addressing the entire meeting, not just you. So I appreciate your agreement, but I'm addressing the entire meeting. Thank you. So in that regard, there are certain obligations under that statute, but there are also obligations under the Regional School District Agreement. And that agreement specifically requires that the town that in which the capital expenditure is to be undertaken, that town must hold a town meeting with respect to the incurring of that debt. And that is a distinct process, distinct from Chapter 71, Section 16. So we can actually hold that separate and apart and look to how that process proceeded. And we've analyzed that. We've discussed it with bond counsel, who advises the Regional School District Committee with respect to the borrowing. And it is the interpretation of bond counsel with which we agree that the process under the Regional School District has been followed and has been satisfied. So that is why we reached the conclusion that the vote that town meeting took, regardless, and I understand that the concerns about that, but that vote satisfies the requirements of the Regional School District Agreement. It does not satisfy the requirements of Chapter 71, Section 16, small d, with respect to the notice to both communities. So that is the process that essentially has to be repeated in order to rectify the error that occurred at that time. And again, it was an error, an understandable error, again, that kind of started from the beginning with respect to the understanding of who was incurring this debt. But at this point, it would be necessary for the school district to reissue that notice to both towns and start that process, that 60-day clock, which may lead to another town meeting. Likely it wouldn't, but in that situation, that would be a possibility. At the same time, the Board of Selectmen, once receiving that notice, would be able to take the vote under Chapter 59, Section 21C, Proposition 2.5, as you folks probably know it. And under that statute, the Board of Selectmen would have to vote by a 2/3 majority of the entire board, so 4 of the 5 members, to send that matter forward to the ballot for a ballot question with respect to the incurring of the debt as a debt exclusion. So that would then go to the ballot. So I do appreciate that errors were made. I'm not sidestepping that issue. I acknowledge that entirely, and deeply apologize for that. But again, the process we're trying to outline now is a process to move this matter forward. It's a decision certainly not for town council or bond council. It's a decision to be made by the district school committee and the Board of Selectmen ultimately as to how to proceed. But there is a procedure, and with respect to the process, we have to look at, as Attorney Blake referenced, the very separate authorities that we're dealing with. The regional school district charts one course that has to be followed, and in our opinion, that has been satisfied. I understand that there's some discomfort in that, but that is an opinion that was given by bond counsel and an opinion that we agree with, that process has been satisfied. The process we're dealing with right now as to the regional school district is whether the district is now going to send out a new notice to both Whitman-Hanson with respect to a vote to approve that debt, and whether that's going to trigger any further action or lead directly to a ballot question. Mr. Chairman.
If
Thank
I
you.
may add, Mr. Chairman?
Yes, go
Very
ahead.
briefly, I also want you to know that that council for the school district also concurs with this as well.
Before I recognize you, Bruce, does everyone understand what the attorneys are both saying? There is a procedure that the district has to follow, and you asked me in the beginning. If the school committee, the first procedure would be, we have sent a letter to the MSBA to find out if they will extend the agreement on the school building. We would have to get a letter from the MSBA in the affirmative for us to move forward. The next step would be the committee to take a vote and determine if they wanted to move forward. Then we would notify the two towns and start the process over again. The committee would have taken a vote if it was in the affirmative. Then we would notify the two towns. Then the towns would have a 60-day period to respond. Am I correct? If I'm incorrect in any of this, don't hesitate to jump in. I just want to let you know where the next step would be, and then we'll take your question, Mr. Young. So then it would be on the onus of the selectmen, after the committee, if they voted in the affirmative, it would go to the Board of Selectmen. The Board of Selectmen would have the opportunity of whether to move forward with bringing it and putting it on the ballot, or having another town meeting. Am I correct, Mr. Rich?
That is correct.
And that would be the ending steps, am I correct?
That is correct.
Okay, so I just wanted everybody to be kind of clear on that. Mr. Young?
Thank you, Mr. Hayes,
Thank you.
and thank you to the attorneys who's attended tonight, and everyone who's attended this meeting. It's another exercise in democracy, as you like to say, Mr. Hayes.
Yes, it is.
Okay, thank you. I'd just like to ask the attorneys a couple of questions about Chapter 7116D, the way I read it. First of all, in looking up Chapter 7116D, does anyone realize when this law first came in? It first went on the books, I have it, in 1949, okay? This law goes all the way back to 1949, back when school committees actually had autonomy over towns. And if nobody knows what autonomy means, that means that the school committee could borrow anything they wanted to do, borrow anything they wanted, and they could appropriate what they wanted and send the assessments on to the member towns and put it on the warrant. And there really wasn't anything a town could do about it. They couldn't raise the assessment up or down. You just had to rubber stamp it, because if you tried to bring it down, the school committee could sue under the law because they had autonomy. Autonomy was removed when Proposition 2.5 came in first in fiscal 1982. I know that because I lived in town since 1971. I was a member of the Finance Committee, et cetera. And, but really, we've never, ever used the part of the law you're talking about in this town. I can tell you that because I've been to every town meeting, and we have never had an article on the ballot. Basically, what the latter part of Chapter 1, 7116D says is that the selectmen have the right within that time frame, the time frame that you mentioned.
60 days, sir.
60 days, if they would like to. And don't forget, this goes back to 1949, so selectmen then would have a chance to rein in committees that they felt were overstepping their bounds, because we didn't have Proposition 2.5 back then. And what that latter part says is the selectmen had the right to put an article on the ballot, not to approve, but to disapprove the borrowing, not the project, but the borrowing, the debt, as authorized by the school committee. It had nothing to do with the article that's going to come later, okay? He says it has everything to do with the article you just voted. It has nothing to do with the article you just
Bruce?
voted. Well, let me finish.
I'm giving you a little bit of latitude because I want
please.
everybody to be
Please, 'cause
understanding, but we have to have a question.
This is an important part I'm making.
That's why I'm
okay?
letting you move
This is
on.
a very important part I'm making.
I love
All
it.
right?
Go ahead, continue on.
Because the second part, naturally, and when the selectmen got if they did get the letter from the school committee who authorized the debt, they filed it. They didn't do anything with it because they knew it was coming next. What was coming next was the article for the $58.4 million school. It's a two-step process. You know why I know it's a two-step process? Because I looked at it. You know why also I know it's a two-step process? Because I called the Massachusetts Association of Regional School Committees, and he told me that what they're trying to throw at you tonight, ladies and gentlemen, is wrong. It's a two-step process. One's an article, and one's a letter, and the selectmen acting on it. And if you buy into this nonsense, that's up to you, okay? But I would like to ask you why you disagree with me.
Mr. Chairman, if I may.
Go ahead.
Mr. Young, I know we spoke before, and I would say the reason I disagree with you is because, unfortunately, you're wrong. And the reason is, and that happens, and I understand it is a complicated statute, and I know that you...
It's nothing
if I
complicated
may,
about it.
Mr. Chairman, if I may...
Yes,
'cause I
continue.
sat quietly
Please let him
while-
speak. Please let him speak,
think
Bruce.
have
I
the
gave you
floor.
an opportunity.
I have the floor now. I think that, it is a complicated statute, and Mr. Chairman, I'm going to continue. Under the statute, there is a very specifically prescribed process. And read carefully, it's well understood that the regional school district committee, the school committee, must vote to authorize the debt. It then must send the notice within 7 days to the two member towns. And once those notices are sent, that triggers an ability of the town, through its Board of Selectmen, to hold a town meeting under the hand of the Board of Selectmen, since the Board of Selectmen has the authority with respect to town meeting, and the consideration there would be, as the statute talks about it, to consider disapproval of that debt.
Thank you.
But that's a semantical issue that Mr. Young is caught up on, and I understand why. But again, it's very unusual language, and it's very rare for a town to posit a warrant article that is framed as a disapproval. Instead, the ordinary course, and it's an acceptable course, is to propose a warrant article to simply approve that debt. It's the same thing in the reverse. And that is what happened. That's the article that was proposed, and that's the article that was put forward at town meeting. That is subject to a majority vote. And yes, that is the second step, but it is not a mandatory step, because what the statute says is that there may be a town meeting action. It does not require that town meeting action, and if no town meeting action is taken within that 60-day period, the debt is considered approved by the town, and it's therefore authorized. The difference here, of course, is that there was the contingency upon a debt exclusion, and in order for the debt exclusion to proceed, that matter has to be brought before the voters at a ballot question. And that's where a two-thirds vote does kick in. And that two-thirds vote is a two-thirds vote of the local appropriating authority, which is the Board of Selectmen. So it'll be a two-thirds vote of the Board of Selectmen to put the matter before the voters at an election with respect to the debt exclusion. There's no timing involved there. So as soon as the Regional School Committee notifies the Board of Selectmen of the authorization of the debt and seeks approval from the town, the Board of Selectmen can vote the very next day to put the matter before the voters at an election. Whether or not it chooses subsequently to go to town meeting, the sequencing is not relevant. But in this case, the sequencing that is relevant under Chapter 71, Section 16, small d, is 7 days notice to the two towns, the possibility that one of the towns could have a town meeting vote to disapprove that debt, and then there's the further step imposed on a separate track of the regional school district agreement that requires the town in which the capital cost is to be incurred for that town to move forward with an article at town meeting, which did occur, and that's a simple majority vote. So that is the procedure. So again, I guess maybe I'm missing the point of what you think.
I think you are.
Said wrong.
I think you are.
But I think that you're misunderstanding the statute.
And the second part of my question is this. If you look at the regional agreement, there's only one part of 16D that is now in the regional agreement. Does everybody know that? The last part he mentioned is not in the regional agreement. The part about taking it to an election for the Board of Selectmen, that's not in there. You know what? You know what's in there? The only thing that's in there is the courtesy of the school committee to send that letter to both member towns informing them that you have just authorized the debt for the $58.4 million school article and demolition of both schools. That's all that's left in there. And you know why that's left in there? Because this law that dates back to 1949 no longer applies, because Chapter 59, Section 59, Chapter 59, 21C, okay, regarding debt exclusions is what we now go under, because that regional agreement was amended in 1991 when we went pre-K through 12. It's not in there. Plus the fact that in your regional school agreement, it says that all capital projects, such as the one we just voted on, have to come and be placed before the Board of Selectmen via an article. Not a notice, not a letter, but an article. So if you go by the way he's telling you to do it, you're going to be in violation of the regional school agreement. You would be required to do what the towns of Shirley and Air had to do in order to vote the way they did it. You would have to put sections 16D and N in your regional agreement, and then have both towns agree to that. Would both towns agree to that? I don't think so.
So Bruce, is
Because
your
the
question...
voters, let me
is
finish,
your
I got one
question,
more
though,
thing to
is your
say.
question... Okay, go
I
ahead.
got one more thing to say.
Go ahead.
And I don't think the voters would go along with it, and I don't think you would go along with it, because you would be denying the voters what they were able to do for the last 35 years since we've had Proposition 2.5, and that is require a 2/3 vote of town meeting for any debt exclusion that came before them. So don't listen to this nonsense, which is what it is. Reject it, and let's move on and get something done to the schools. Let's all get together and do it.
Mr. Chairman?
Doing nothing
Bruce,
is not an option.
Bruce, is that your question, whether
That's
this
my
law
question.
applies?
That's
the
my
law that you
question.
just stated, whether it applies now or whether it's an outdated law? Is that
Of
your
course
question?
it's an outdated law. That's why it's not in your
Mark?
agreement.
Mark, do you want...
Mr. Chairman, if I
Go
may,
ahead.
thank you.
Go ahead,
Again,
Go ahead, Attorney Rich. I have a question for you when you're done.
If I may, I'll briefly address the comment, because I think, again, there's confusion. Mr. Young is somehow suggesting that Proposition 2.5 has to be included within your regional school district agreement, and that's not correct. Excuse me, sir, that is what you said, or if you did, then what you said was so confusing that it's misleading. It's misleading.
Okay, please stay in order, ladies and gentlemen. This way we will all be on the same page. Bruce, he gave you the opportunity to speak, and so did I. Please let him speak.
It's very difficult, Mr. Chairman, to be told that what I said was nonsense, and then to have Mr. Young hectoring me from the audience, but I'll move
I
forward.
understand. I'm asking for your indulgence.
I appreciate that.
As you understand, this matter is a very difficult matter, and it's a capital article that's spending a lot of money. So that's why I'm giving a little bit of latitude. So I'm asking for your patience with me also, please.
Mr. Chairman, and
Thank you.
I'm not trying to make light of it. It's just, it makes it very difficult to try to parse through what are difficult statutes. The regional school district agreement is ultimately subject to certain provisions of law. And the regional school district agreement does not in and of itself contemplate debt exclusion. Debt exclusion is a concept under Proposition 2.5 and under Chapter 59, Section 21C. So there is nothing in the regional school district agreement that talks about a debt exclusion, because a debt exclusion is not a requirement. That's an option that is allowed to the town. And in this case, that is an option that was imposed into the warrant article that was submitted to the Board of Selectmen by the Regional School District Committee. So it did, again, complying with the agreement. And the situation now is there is absolutely no foundation in law to suggest that a debt exclusion is subject to a 2/3 vote of town meeting. It is subject to a 2/3 vote of the local appropriating authority. And under the statute, that is specifically defined as being the Board of Selectmen. So while folks might be unhappy with that, the statute was written specifically with the intent that once you get that 2/3 vote of the Board of Selectmen, that allows the matter to get before the voters, and ultimately the democratic process will prevail because it gets to the voters at an election as opposed to the smaller forum of a town meeting. It is brought to the broader forum of a town election as opposed to a town meeting vote. So again, it is not subject to 2/3 vote at town meeting. It is subject to a 2/3 vote of the Board of Selectmen to put the matter before the voters at a election, a town election by the town. Thank you, Mr. Chairman.
Thank you very much. My question to you would be, Attorney Reach, I
Yes.
heard you say earlier, it would be a vote by the Board of Selectmen, being a two-thirds vote, and you said of the entire board. Is that the entire board that is there at the time?
It is the entire, Mr. Chairman, that is a two-thirds vote of the entire board. You have a five-member Board of Selectmen, it would be a two-thirds vote of the five-member board. So it's not a situation similar to a two-thirds vote of the members sitting. It is a two-thirds vote of the board.
Okay, so an example that I would be asking you, it would be 4 out of 5, and I'm just trying to make it clear for everybody here. It would be 4 out of 5. Now, what would happen if only 4 members showed up, period, for the next 2 years? How could you take that vote? I believe it says all members present that you have a quorum with.
That's what I believe too. Bob's right.
I'm just asking, I'm just trying to get everything as clear as possible.
I'm trying for your benefit to find the
That's
the
okay.
specific statute. Yes, two-thirds. Yeah, the local appropriating authority of any city or town may, by a two-thirds vote, seek voter approval at a regular or special election to assess taxes in excess of the amount allowed pursuant to this section for the payment of principal and interest, notes or certificates of indebtedness, including tax revenue anticipation notes issued by the town, city or town, and for the city or town's apportioned share of the principal and interest on such notes, such bonds or notes issued by regional governmental unit, which were outstanding as of November. It goes on, and then it actually provides the actual question to be asked.
There's no requirement, two-thirds president, you're right.
Pardon me?
President voting, he didn't specify two-thirds of the board. You said
It's a two-thirds
of the board,
vote.
doesn't say.
It's a two-thirds vote.
Is it a two-thirds vote, though, of the present members that receive a quorum of the
It
meeting?
doesn't specify it.
Yeah, it's a two-thirds vote. So if you, it was your question, if you had 4 members?
If you had 4 members, you would
it'd be a
need 3
two-thirds-
to 1.
It'd be a two-thirds vote of the 4 members.
That's what it
Okay,
says. That's true, that's what it says.
okay.
That's not what it says.
Yeah, that's, again, it would be the two-thirds vote of the local appropriating authority. In a town, the Board of Selectmen will be a two-thirds vote of the Board of Selectmen.
Does it say it?
Okay.
It would say specifically if they said the full board.
Do you have a question, sir? Can I have your name and address, please?
Referring to me?
Yes, sir.
Blowing back me. Okay. In the opening meeting, in the opening statement, I have a problem with, I didn't come in here tonight with this particular question. But young man, in your opening statement, you said that we have the majority, oh, not the majority, but more than half the
It's a
vote.
majority.
Okay, was taken, we've already met the fact that the more than two-thirds or more than half of the vote in the town meetings conferred the fact that we didn't have to have another town meeting. Is that right?
Yes, that's what I
Right?
said, yep.
But I don't know how you can say that when it was introduced as two-thirds vote. When going to the town meeting, it was known it was a two-thirds vote. But now it don't matter, because you're saying that it only had to have
A majority,
a majority.
that's correct.
But the people that showed up, or didn't show up, understood it to be two-thirds. So now you're saying that it had to be more than half.
That's correct.
And so you don't need to have another town meeting when the rules are changed as to why people showed up?
Well, what I'm saying is that the rule has already been the rule which we find in the agreement, understand under the statute, there's no requirement of town meeting. What I'm saying is that under the agreement, that rule has been met. It was supposed to be a majority by law. So even though we may have gotten up there and declared that it failed because it didn't get the 2/3, it did in fact by law pass twice. So that's what I'm saying.
Under the guise of that, but not under the guise of the way the meeting was held. Okay? So people show up knowing that it's going to be a 2/3 vote. Or people don't show up knowing it's going to be a 2/3 vote. It just has to be a little more than half. So how can you say, under your rules, that the meeting applied when people decided to come or not to come based on the 2/3?
Well,
I don't know how you can just disregard that by saying now, after the meeting and after it was explained it was 2/3, that we've already met your objective. And I don't think, based on the meeting and the way it was held and the way it was proposed, that if what you're saying would have to have those meetings over again, so everybody would know that they would just have to meet the majority.
but if you were to be in opposition to the article, I would think that knowing that there was a 2/3, we would have gotten more people to come out because it was a more stringent. And you understand,
Sir.
2/3.
Please, ladies and gentlemen,
Sir, is that your
everybody
opinion?
listen so there's no
Just-
gray
Is that
area
your
when we leave
opinion
this
or is
meeting.
that your judgment?
Well, hear me out.
Is that your opinion or is that your judgment? Are you judging that that's the case or is that your opinion?
Well,
I just, one or the other.
no, it's not a yes or no
Just
question.
answer the
okay?
question, yes or no.
No, it's not a yes or no, and I'm going to explain myself, or I'm not. What I'm saying is that by law, the article passed twice by a majority. Now, what I think you're trying to say is that had other people known that it required less than a 2/3, that they would have come, understanding that 2/3 is more than a majority. So
I understand what 2/3 is.
Okay, all right.
66%.
Well, I'm
It's
sorry?
66%.
Yep, 66.6. You're right. Yep.
Yeah.
So.
Well, I think I understand what 2/3 is.
Okay,
When you
fine.
explain that to me,
Please let him
it's more
finish.
Fine.
Please let him finish.
My-
This isn't
my
a
point is
debate,
that
this is
by
a
a-
question and answer, please.
As a matter of law, that it passed twice at town meeting. And that's my opinion, and the two town meetings that were held are sufficient to get us, over, or in compliance with the agreement. I've said that as town council. Bond council has said that, and I don't want to be condescending to you, sir, but if you, a lot of times I'm not sure you know what bond council is, but bond council is counsel for the company, the people that issue the bond. So if bond council says it didn't comply, then the bond companies won't give you the money and we won't get it. So we go through bond council with these. Bond council said it's in compliance, and the regional school districts council agreed as well.
So that was a 10-minute discussion on whether it was your opinion or not. You suddenly said it was your opinion.
I believe he
Is
answered
it
your
your opinion
question.
or not? That's all I asked. Is that your opinion or is that your judgment? You said it was your opinion.
Sir, I guess,
I just want to
come in for a second.
I want to be clear on the
I
fact
wanna
that
be
he
clear
said it
that-
was his opinion.
We don't issue judgments. We don't wear the black robes. We're not judges. So all we can issue is your opinion. So maybe that's the answer to
You
your question.
understand what
And
opinion
again,
is.
it's an opinion that was issued by us, by bond council, and by district council.
You understand the definition of opinion?
Yes, I absolutely do. I
We're
absolutely do, sir.
looking for a question and answer, we're not looking for you to school us on what opinions mean. He is an attorney who has given you his opinion. Does anyone else have any questions? Yes, sir, he's been waiting very patiently up there. Your
Mike
name and
Doc-
address, sir?
Mike Doherty, 803 Pleasant Street. Are you two attorneys with the same firm?
Yes, we are.
This next question goes to the chairman of the Board of Selectmen. Why hasn't this firm been fired? And why did you bring these same two guys back here to try to redefine what they don't already know?
Mr. Doherty, Well, let the board, I'll give you a little leeway and let the chairman of the board address that question, but I believe it's out of order because it's nothing that is on tonight's agenda to be discussed. We are discussing the vote, not the hiring
Right,
and
and
firing.
the vote is a mess because the lawyers didn't do their job.
But we're
And they're
not
here trying
discussing
to
the hiring
explain
and
to us
firing of
what the
attorneys.
problem is, and they shouldn't be here doing it.
Jim, would you like to answer that question? I don't believe it's relevant tonight, so I'm going to move on.
Okay.
Thank you.
Yes, good evening. Michael Murray, 254 Lakeside Road. Would town council agree that the warrant as printed was defective? That it did not require a two-thirds vote, but a simple majority? The warrant for both previous town meetings stated that a two-thirds majority vote was needed to pass. And if the warrant was defective, taken to court, shouldn't the warrant itself be thrown out and just simply have another town meeting? I don't care if you build a school or not. It makes no difference to me. To me, this seems more of an issue of voter rights at this point. That's my concern. Thank you very much and have a good evening.
If I may, Mr. Chairman.
Go ahead.
I can try to answer that. I'm looking at a copy of a document that I don't see anything that specifically says two-thirds vote on the document, but again, the warrant article as presented was properly presented. The issue is, as of law, what is the quantum of vote? The quantum of vote was a simple majority, so no, I don't think the warrant was improperly before town meeting. And again, as to the issue of the rights of the voters will, in fact, be protected because the matter will be before the voters at an election as deemed by the Board of Selectmen. If the Board of Selectmen chooses not to put the matter before the voters with respect to the debt exclusion, the matter is done because that contingency will never occur. So the only way this goes forward is at the election.
I think I can answer your question, not to interrupt, but I understand his version. I'll give you maybe a little simpler version. As I was explaining, we have sent a letter to MSBA to ask them for an extension of our agreement with MSBA. If the MSBA comes back and says that is not going to happen, this point is a moot point.
Correct.
Then the next process would be this 10-member school committee would have to vote to take on whether we're going to send the debt authorization to the selectmen. And then the selectmen would have to vote whether they want to put it on the ballot or they want to have another town meeting. So in talking about what you're talking about, your nullification, this is going back to the right of the voters. If there were missteps, which I agree with what you're saying, totally, this is the correct procedure to correct what the missteps were. So if you're truly looking for the democratic process in this, the missteps were done. Everyone admits that. This is the correct process to move forward. And I'm not trying to, I'm just trying to get to it.
The only point that I would like to bring up is that you cannot turn around and say that the question passed because you had a majority. You asked for a two-thirds vote. On town meeting floor, that could have been amended to 50%. It was not. The question that was asked to the voter had a two-thirds requirement at time of the vote. You people could have modified it on the floor. You proposed the question. You all reviewed the question. That's your fault. You put that requirement upon yourself. That's it.
Thank you very much. There's another gentleman up back that's been waiting.
Good evening, ladies and gentlemen. My name is Tom Constantine. I live in Brook Street in Hanson. As I understand it, you folks want to invoke Chapter 71, Section 16, Paragraph D. And I'm somewhat perplexed. I understand, I've read the law multiple times, and that now you want to walk it back, certain sections of the entire procedure, and walk certain things back. And what I don't understand is, initially when you, I believe it was Mr. Rich, opened up his dialogue, he mentioned that the process had been tainted, and I agree, but it's, in legal parlance, it's called the fruit of the poison tree. It's not certain sections are tainted, the entire process has been tainted, and you're gonna have to go back, as somebody mentioned or earlier, is you're gonna have to go back from square one, in my opinion, just as you have your opinion. And one other thing too is, I noticed that you left out paragraph N is in November. If you'd be kind enough to read that to everybody else, because I believe that also stipulates that both the town of Whitman and both the town of Hanson will require elections. Thank you.
Mark, Mr. Rich?
Yes, thank you, Mr. Chairman. I don't think I used the word tainted. I think I talked about errors. But again, you know, the poison fruit of the forbidden tree is an evidentiary concept, and it's a good one. But in this case, we're talking about a very, very different concept, and we're talking about, again, concepts that arise from the regional school district agreement and from state statute. And the agreement imposes certain requirements, the statute imposes other requirements. And right now, what we're dealing with is where we stand with any of these procedures. And again, the regional school district agreement had a requirement that the matter must go before town meeting, again, conferring with bond counsel and getting the opinion of bond counsel, getting the opinion of district council. The general opinion is that the requirements of the regional school district agreement have been satisfied. And now it's a matter of addressing the requirements under Chapter 71, and then subsequent to that, addressing the requirements of Proposition 2.5 with respect to the debt exclusion. So that's where we are. And I think, Mr. Chairman, you very well summed up the process that we're undertaking tonight.
Right, that would be the restart. To answer the last gentleman's question before we get to this gentleman right here, I can read you what was read on the warrant. To see if the town will approve $58,436,926 borrowing authorized by the Whitman-Hanson Regional School District, the district, for the purpose of paying costs of demolishing and removing the existing McQuon Elementary School located at 38 School Street and the Indian Head Elementary School located at 720 Indian Head Street, and designing, constructing, originally equipping, and furnishing a new pre-K kindergarten through grade 5 elementary school to be located at 720 Indian Head Street, Hanson, Mass., including the payment of all costs incidental and related thereto, the project, to replace the existing McQuon and Indian Head schools, which proposed project shall have an anticipated useful life as an educational facility for the instruction of school children of at least 50 years, and for which the district may be eligible for a school construction grant from the Mass School Building Authority, furthermore MSBA, said amount to be expended at the direction of the School Building Committee. The MSB's grant program is a non-entitlement discretionary program based on need as determined by the MSBA, and any project cost the district incur in excess of any grant approved by and received from the MSBA shall be the sole responsibility of the district and its member municipalities. Any grant that the district may receive from the MSBA for the project shall not exceed the lesser 59 7/100%, i.e. 59.17 of the eligible approved project cost as determined by the MSBA on the two total maximum grant amount determined by MSBA, or take any other action relative thereto. It did not speak to that it would take a 2/3 vote when the article was read. I just wanted to clarify that for the last speaker. I have the article as was read, so. That's the article that was read. Yes, sir.
First off, I'd like to say...
Can I have your name and address, please?
My name is Millage Corcoran. I live at 50 Franklin Street in Hanson.
Thank you.
First of all, I'd like to have you on me the same courtesy as you do the lawyers and let me have my say. Don't cut me off.
You're doing it right now as long as you're asking a question.
Now, my question to you and to the lawyers are this. At the town meeting we had a few weeks ago, the subject of the school district, regional school district, was brought up. How come all this explanation wasn't pointed out at that point?
I can read that. I can read that to you right now.
Well, you just read it, but it don't mean nothing.
No.
You admitted it don't mean nothing, so you can read it all you want.
This is a whole different thing. You want an answer to your question?
Yeah.
Do you want an answer to your question?
Yeah.
Okay. On Wednesday morning, January 29th, the Director of Business Services for the Whitman-Hanson Regional School District, Christine Succo, was involved in a phone conversation with Lisa Dickerson, Senior Vice President and Manager of Unibank Fiscal Advisory Services. When Ms. Dickerson inquired about the vote on Saturday's town meeting, Ms. Succo replied that the vote had gained a majority, but had failed to acquire the two-thirds for it to move to a secret ballot at an election. Ms. Dickerson replied that it was her understanding that a two-thirds majority was not required for building project votes in the original regional school districts unless specified in the regional agreement or town bylaws. Following the phone conversation, we were notified and began the process to address Ms. Dickerson's comment. This process included a review of the regional agreement, an examination of the bylaws for the town of Hanson, input from Rich Manley, Hanson's bond counsel, and conversations with the Hanson Town Administrator, the chair of the Regional School Committee, the chair of the Board of Selectmen, and the chair of the Elementary School Building Committee. In addition, contact was made with the school committee's attorney, James Toomey, from Murphy, Hess, Toomey, and Lanane, and the town's attorneys, Jeffrey Blake and Lauren Goldberg, Koppelman and Page. Representative Josh Cutler, the Department of Revenue, the Mass Department of Elementary Education, referred to as the DESE, and the Massachusetts School Building Authority, referred to as the MSBA. Conference calls were held with town officials, school district administrators, attorneys, and the project manager on January 29th and January 30th. The conclusion was reached that as the regional school committee is the appropriating authority, not the town of Hanson, under Mass General Laws, Chapter 71, Section 16, small d, the town vote was a simple majority to disapprove authorization of the regional school committee to incur debt toward construction of the new school, and therefore did not require two-thirds supermajority. The option to place debt authorization to a town meeting under Mass General Laws 70, 16, small d, is at the discretion of the Board of Selectmen. Therefore, it was determined the vote was, as certified, was passed.
Well, you've gone all the way around it. You haven't answered it.
That's a definite
The town of
answer.
Hanson voted twice against your school proposal. And you're standing up here and telling us you're going to stuff it down our throat no matter what we say.
No, that's
The
not
town
what I
has
said.
already said no twice, but you
not
don't
what I
want to
said.
listen.
That's not what I said.
I talked to you at the town meeting personally, and I asked you about the school district, about putting a school over here. You said it doesn't count. That's what you told me at the last town meeting.
What doesn't
Now
count?
you're telling me that the lawyers tell you it is right. This
I'm
is a
not a
shell
lawyer,
game that
sir.
you're playing.
I'm not a
You're playing
lawyer,
a
sir.
shell game, and it's going to back up and fire on you.
Okay, thank you. The gentleman up in the back.
Thank you, Mr. Hayes. My name is James McGann, 27 Beechwood Road, Hanson. I got a question with regard to the MSBA loan. I'd like to know, after I speak, if we could please have read out loud what exactly was said to the MSBA after the January vote. And after that, I'd like to ask a particular question with regard to the policy, since we understand now that policy and procedure is very important. My understanding is that MSBA policy says that after 10 days of the vote, 3 things should come to them. One is basically the vote for and against. Second one is the reason why it failed. And the third reason is the remediation plan of it. Part of that remediation plan of the October vote, if my understanding was correct, was that a town meeting was to be held. So if the town meeting doesn't hold true, that happened on January 25th, then would it be true that the plan that was sent to the MSBA is no longer true? And therefore, we've also gone over the 10-day period.
Go ahead, Ruth.
I'm going to give you the sequence of events that happened after the town meeting on January 25th. The school committee, the district absolutely believed that the vote had failed. On Monday morning after that vote, I called Diane Sullivan at MSBA and indicated that it had not achieved the 2/3 that was required to move it to a secret ballot, and that it had failed, and that we would be sending them a letter indicating the 3 points that you talked about. We then had a building committee meeting the night after, that very night, to talk about, well, if it didn't pass and we can't move forward, what are we going to do in Hanson about the 2 schools that need significant repairs? The next day, I called Ms. Sullivan back, indicated that we would look for a little bit of an extension. We were going to have a meeting with the Board of Selectmen, FinCom, School Building Committee, and the the school committee to really determine what was going to come next. And that was the plan. I'm going to write the letter. It was the very next day, totally unaware of anyone, that the conversation took place between Ms. Dickinson and Christine Succo, indicating that a two-thirds majority was not needed, just a simple majority. At that point in time, we called MSBA, and I said, everything I told you Monday and Tuesday isn't really what we're going to be able to do. And we were in conversation with them. I then have written to them, you have a copy of the letter, indicating that we really needed to have this meeting. We had to realize what had to be restarted. We had to speak to attorneys, and they have said to us that letter is sufficient for now, and they're going to wait to see what happens here. I'll be in contact with them, and at this point, they're holding the funding, but they won't hold it forever, and they weren't able to give us any, I can't speak for MSBA in terms of what they're going to do.
So essentially, MSBA policy, they're ignoring their own policy after the 10 days and
No, they're not. No, I had to respond to them in 10 days. You have a copy of the letter, and at this point, we don't know whether the vote failed or not. It certainly failed a two-thirds majority, and that's what we believe to be true. MSBA doesn't get into that, whether it's a majority or two-thirds, because it varies from town to town and agreement to agreement, and that's not their
The
responsibility.
policy is quite clear on MSBA's site, though. It does say after 10 days.
And we have contacted them, and we have been in conversation. They're very aware of our
And the
circumstances.
plan that we sent them after the October vote was basically invalid.
It can't work.
Right.
And so, and it's
So
going to
therefore,
expire
we've broken the
anyway.
plan, we've broken that policy.
But if you
We've gone past the time. And yet, policy is very important for us to follow on the other hand, isn't it?
Well, we have followed it. If you read the letter that was in your packet, it's the letter that went to Ms. Pachetti at MSBA indicating what the plan is.
Ms. Whitner, this certainly seems like that
Dr.
we're
Whitner,
choosing
thank
to
you.
pick and choose which policies we so choose to follow, isn't it?
Well, we are following the guidelines of MSBA at this time, and that's really the best we can do.
Mr. Trotter?
Is this mic on? Can you hear? We've been sitting here for about 50 minutes or so, and it's obvious to me and probably everyone in the room that there's a lot of negative energy. There seems to be a lot of tension, a lot of anxiety and mistrust of the process. I guess my question is, what is the easiest way to streamline the process? I mean, we could probably sit here another hour and listen to negative comments. I don't know if anyone any positive. But I don't think it's necessary to sit here for another hour. I'm getting the feeling that I get the feeling what the majority, so people have spoken. I don't know if there's any pros in the audience, but what's the easiest way to streamline? I know we have to go to the was it MSBA, right?
Yes. The next step is a letter from the MSBA stating that they will continue to hold our agreement until we come to some sort of a conclusion.
So-
If they deny that agreement, this process is over.
So nothing can really be done until we get word from them, is that correct?
That's correct.
Right.
Nothing can be done. This was an informational meeting held to try and, there's a lot of talk going around town, Bob. There's a lot of, as you said, this negative, this positive energy, and there's a ton of people that are involved, and this was to try and get some of the process straight and let people know where we're going from here. But this is, the next step is truly, it's in the MSBA's hand. If they send a negative, then the funding is gone, and this is a moot point. This meeting was for nothing, other than we all got an education on how to build a school and what steps to take.
Okay, thank you. I guess, again, like I said, I don't know if anyone's here with any positive remarks, but I certainly got the gist of what the consensus is here this evening. Thank you.
Anyone else on the committee have any questions?
I do. Just from the two articles.
Name and address?
Ken Verity, Indian History.
Thank you, sir.
Are we voting on the same article that, not voting, or is this the same article that was written in Article 25 that is in Article 1? Is it the same article?
That's the article.
Is it the same article? It's one on October's meeting, the Article 25, and is it the same article as on the January meeting, Article 1?
I'm reading the one from, It says, "In the name of the Commonwealth, you're hereby directed to notify and warn the inhabitants of the town of Hanson qualified to vote in town affairs and elections to meet at Whitman-Hanson High School, Franklin Street, in said Hanson, on Saturday, the 25th of January." So this was the one that was read on the 25th of January, 2014 at 9 o'clock. I don't know about the October one, I don't have it.
It is written different.
I have the January one.
You wrote it totally different. The one in October is different than the one in January.
If you'd like to give it to me, I'd be more than happy to read it.
Okay? And the numbers are the same, but the wording's different.
I'd be more than happy to read it.
Like many come upstairs, are you?
Pass both times, it doesn't matter. Now it's changing the articles, the new vote of the committee. You change that article to a whole article.
This is from the budget, town budget and warrant budget recommendations, October 7th, 2013. Reading from the front of the page, so there's no errors. Article 25, to see if the town will approve $58,436,926 borrowing authorized by the Whitman-Hanson Regional School District, further called the district, for the purpose of paying costs of designing, constructing, and originally equipping and furnishing a new pre-K kindergarten through grade 5 McQuon Elementary School to be located at 720 Indian Head Street, Massachusetts, Hanson, Massachusetts, including the payment of all costs incidental or related thereto, the project to replace the existing McQuon and Indian Head schools, which proposed project shall have an anticipated useful life as an educational facility for the instruction of school children for at least 50 years, and for which the district may be eligible for a school construction grant from the Mass School Building Authority, MSBA, said amount to be...
I see what you're saying now.
Please, ladies and gentlemen, we want everyone to leave on the same page, so please listen. Said amount to be expended at the direction of the school building committee. The MSBA's grant program is a non-entitlement discretionary program based on need, as determined by the MSBA, and any project cost the district incurs in excess of any grant approved by and received by the MSBA shall be the vote responsibility of the district and its member municipalities. Any grant that the district may receive from the MSBA for the project shall not exceed the lesser of 59 0.17% or 59.17 of eligible approved project costs as determined by the MSBA, or 2, the total maximum grant amount determined by the MSBA, or take any other action relative thereto. How are you saying it
So
reads?
the numbers are the same, but the words are different. Nowhere on anything, any literature on the October meeting was the demolishing of the McCollin and the Indian Hill School published anywhere. You can't find it in print anywhere on anything leading up to the October meeting. And it's not in the article. But the numbers are the same on Article 1 as they are on Article 25.
I think possibly, and again, I don't want to put words in anyone's mouth, but I think it says to replace the existing McQuon and Indian Head elementary schools. And the other one says, to replace the existing McQuon and Indian Head schools should be an it may have, for the purpose of paying the cost of demolishing and removing the existing McQuon Elementary School located at 30.
There's the difference right there.
Yeah, that is the difference in the article.
That's the difference.
I'm assuming, and again, making assumptions, I am not an attorney, but maybe
Why would you have another meeting on the same subject, we change the words on the article?
I don't know, maybe they realized the article didn't say demolishing the schools and we weren't going to leave all 3 up. I don't know.
So where is in the numbers?
Numbers are the same.
In the numbers, where does the tearing down, demolishing, and resolving the property afterwards, where does that lie? In the 58 or the 8 million?
It's in the $58,436,926.
That's totally covered.
That's the total cost of the project, including tearing down both buildings that are currently there.
Okay, so it's not will somebody explain to me what's in the 8 million?
What are you looking at, sir?
Yeah, the 8 million, what do you consider the the ineligible?
That's the fields for one.
That's part of the cost of the original building, which we broke down at both meetings. But thank you very much for the question, because we're trying again, I'm giving latitude to stay on what the meeting was about, trying to keep this meeting and get everybody so there isn't any gray area, because that appears to be the problem. Bob hit it right on the head. Young man?
How you doing? Dean Weber, I'm from Jean Street. What I'd like to know is we had a vote, it was presented by the town manager, we were given instructions, it was a 2/3 vote, it went down and everybody took their vote, it was recorded, I'm assuming to be recorded and validated, is that true?
I believe that the town clerk recorded the vote and validated it. Yes, I believe that.
So what is the procedure to disallow it or nullify that, or how does that work?
Doesn't nullify it.
Well,
We just totally toss it out the window.
I think if we listen to what the attorney said, there was a misstep in the process. It doesn't say anywhere in here, and I read to you both of them, that it was
Okay, that's his
that it was a
opinion.
2/3 vote.
It's his opinion that there was some missteps, and that's fine, but what is the process? How do you go about now, after it's been recorded, and just turn around and nullify a vote? We voted
not
per
nullified, it's
instructions as given. Now, whether it was his opinion, attorney's opinion, that it's incorrect, but it's been booked and logged. Now what?
I think I explained that a little bit of how the restart would happen, but I can go over it again. I have no problem with that.
I know what you're talking about, a restart, I know what you're talking about, how to go ahead and proceed forward, but how do we sit there and take and say, we're not gonna, that vote was already booked, logged, and we're gonna say it doesn't exist?
I think that would be a good question for the attorneys.
No, it exists. It just exists as a majority vote. Yeah, it exists. It's
Mark?
just a majority vote.
Jeff?
Thank you, Mr. Chairman. Again, I think what we've said from the beginning is, we're not saying that that vote didn't exist, we're saying it did exist. What we're saying is that the declaring of the quantum of vote was incorrect. So the vote that was achieved was a majority vote. By action of law, that's a passing vote, regardless of the determination made by the moderator stating that it was a 2/3. By action of law, a majority vote carries in that instance, and that satisfies the requirement of the regional school district agreement.
That's what we call a bait and switch. When you tell somebody it needs one set of rules, and then you go ahead and apply a different set of rules after the fact. When you notify, it's the presentation of what you're saying, and you go out there and you say, this is what is needed, this is how it's going to be held. You can't sit there, I don't believe anybody can sit there and tell you, these are the rules, and then change it. That's nothing more than a bait and switch. Albeit, maybe it was done inadvertently, but the vote was done by rule, by the way it was taking place by the...
No,
Where does it explain? The moderator gave it to us, it's been booked, it's been known, I just don't get how you turn around and say it's no longer in the books.
Mr. Chairman, I understand the
Go ahead.
frustration,
Go ahead, Commissioner.
and I'm not saying that it's no longer on the books. In fact, just the opposite. I'm saying it remains on the books, but unfortunately, the direction that was given at town meeting was incorrect, and that the quantum of vote by action of law is a majority vote. So I'm not saying that the vote doesn't exist. I'm not taking it off the books. What I'm saying is that again, and it's my opinion, it's the opinion of bond council, it's the opinion of school district council, that a majority vote is sufficient by action of law, and therefore the vote carries.
The vote has been certified, correct?
I believe that
Certified?
I believe that the vote is certified.
How do you decertify the vote?
The vote was certified as a specific number. The number of votes, yea and nay, have been certified. It's the outcome that is different by action of law.
Up in the back, you've been waiting patiently. Go ahead.
Good evening, Monitor. Thank you for recognizing me. My name's Kimberly. I live on Glenwood Place in Hanson. I appreciate everybody on the stage admitting that you've made a mistake. However, I don't appreciate the comments that were made about how we feel about the dishonesty and the negativity. You didn't make the mistake once. You made the mistake twice. How are we, as voters and citizens who elected you all into office, supposed to trust you, supposed to put you in charge of our children without not even an apology from you? I'd like to know, and I'd like to know from everybody on the stage why you feel that it's acceptable that we, the citizen in the town of Hanson, should think it's all right and should just forgive you without a fight. As far as I'm concerned, I'd like to know the process for every single one of you to resign. Because you didn't make the mistake once, you made the mistake twice.
So what would be your question?
Do we, the citizens of Hanson and voters who elected you all to office, have the right tonight to ask you all to resign?
I believe there is a process in place for doing that, but
I'm not asking for recall papers. I'm asking them to voluntarily resign.
Well, let me just
I'd like the legal opinion. They're not just hired for you on the stage. We, the taxpayer, pay their paychecks. We pay their firm.
I understand that. Would you like your question answered?
I would, please.
Okay, you're asking for an apology. I personally apologize to you.
Thank you, Tom.
I'm the chairman of this board, so I am the person that has to apologize and speak for the other 9 members here. So I do apologize. But I would like to remind you that the people that you elected on this board are volunteers that do this for free. And the only reason some of them aren't here is because you're not, okay? So having said that,
You want to argue that I'm a state commissioner of 28 towns. I'm elected and I do my job
You're out
for
of
free.
order. Would you like an answer? I was very gracious enough to be quiet and listen to you. Now I'd like to finish, please.
They ran. They knew it was a volunteer job, no different than I did as a state commissioner. And I'm not paid for what I do for the town of Hanson or for the town of Whitman through the mosquito control projects either. It's a poor excuse for making a mistake twice. But my real question is under Chapter 71. I would like legal counsel, since they're bringing in the outdated law of Chapter 71, to please read in Section 16, E and F of that law for the residents of Hanson.
Thank you. Mr. Rich?
Mr. Chairman, is the question simply to read the law?
I believe she wanted to hear E and F of Chapter 71, small d.
I assume Chapter 71, Section 16. We'll start with the first paragraph. A regional school district established under the provisions of the preceding section shall be a body, politic, and corporate, with all the powers and duties conferred by law upon school committees, and with the following additional powers and duties. And then E, to issue bonds and notes in the name and upon the full faith and credit of said district. Said bonds or notes shall be signed by the chairman and treasurer of the district committee, except that said chairman, by a writing bearing his written signature and filed in the office of said treasurer, which writing shall be open to public inspection, may authorize said treasurer to cause to be engraved or printed on said bonds or notes a facsimile of said chairman's signature, and such facsimile so engraved or printed shall have the same validity and effect as said chairman's written signature, and each issue of bonds or notes shall be a separate loan. F, to receive and disperse funds for any district purpose. Those are procedural provisions. That's not pertinent to what we've been discussing, but those are procedural provisions of the statute.
Okay, thank you. Yes, ma'am.
Hi. I have a couple of questions. You said if anybody has a gray area, I have a gray area. You are going to write a letter, and you have to write a letter to both Whitman and Hanson. Is that a correct statement?
That's correct. To notify them of the borrowing.
Okay, Whitman and Hanson. Hanson selectmen of 4, 3, whatever, a majority of their selectmen. 3 out of 4, 4 out of 5, or 3 out of 5, okay, have to vote that it will, that's what I'm not sure on. Is it going to then go to a town meeting? Is that what they're going to vote on? Or is it then going to go to ballot?
Okay, let me answer your first question before we move on. The selectmen have the authority to put it on the ballot or to request another town meeting.
If I may, Mr.
Go
Chairman.
ahead.
There are, again, two parts to this. The selectmen, in response to the action taken, the notice that you just referenced from the Regional School Committee, the selectmen would have the ability, by simple majority vote, to put the article before town meeting once again under the statute for approval or disapproval of the debt. With respect to the debt exclusion, the Proposition 2.5 debt exclusion, that's the 4/5 vote, the 2/3 vote of the entire Board of Selectmen to put the matter on a ballot for election by the town. So not a town meeting, but a town election. There's a difference between the two.
Yes,
so that would go to all the
obviously.
voters for elections. So there are two possibilities. The Board of Selectmen may or may not go to town meeting, but if this is to move forward at all, the Board of Selectmen would have to approve the debt exclusion ballot question.
Okay.
Okay.
If they don't put it on a ballot, and if they don't put it to us at a town meeting, where does it go? Does it go away? Or does it then come back to you?
No, they have to either put it on the ballot for the town's vote, or they have to have another town meeting. It's one of the two. It doesn't just go away. They have to
So-
make a decision.
So it's not 3 or 4 people in the town of Hanson that will be making that decision for the whatever the hundreds are that we're going to be paying out on this loan?
Absolutely not.
Okay, now, you sent a letter now to the Board of Whitman notifying them.
Yes, and that will be
And what-
after the vote,
After your vote.
after the school committee's vote. We would have to send a letter to Whitman and to Hanson if
Now
the
what-
process got started again.
Now, as the matching or however you want to put it,
Regional school
town,
partner.
what do? Do they have to put it on a town meeting, or do they have to put it on a ballot in order for them to vote?
They can choose to do nothing. They don't have to go to a ballot or a vote. And Mark, can you answer that?
Yes, if I may, Mr. Chairman. Since we are under a regional school district agreement, as you indicated, there's a requirement that both towns be notified. But the statute allows both towns to do nothing with respect to a town meeting vote, which would mean that the borrowing authorized by the school committee is approved. So Whitman doesn't have to do anything. With respect to the debt exclusion, since the funds are going to be paid solely by the town of Hanson, Whitman does not have to put that before its voters. That contingency is with respect to the town of Hanson. So in effect, the town of Whitman doesn't have to do anything.
Okay, so we will be voting on by ballot, and I'm assuming that the selectmen will send it to ballot if they want the money. Am I correct?
Yes.
Because we are now overriding Prop 2.5.
It would have to be a ballot question, or it would have to be another town meeting. I can't speak for the Board of Selectmen, but I know that they're very fair, and they probably would go to the, I would guess that the fairest way to do this probably would be the ballot question, and this is what it's getting to. Should it be on a ballot question or shouldn't be?
Okay, now if it goes to town meeting
Yes?
by ballot, by the grace of the selectmen, should they so choose to, what will it then require for our town of Hanson to fund the school or tell the school, go away?
It would require a majority vote.
It is a simple majority vote in order to overrule the $29 million that they will be giving us, the 29 million, or whatever it is, 30, let's do it in round figures. I do my checkbook in round figures. Let's do $30 million that they're going to give us, the MSBA, and the $30 million that we're going to match, because they will not fund the extra money that it'll take to destroy and remove the 2 schools that are currently there. And that's approximately, what is it, $11,000? Plus you've got incidentals. So all that money will then be put on the ballot. Am I correct?
No.
Okay, this is why I'm asking
Well,
questions.
I think they're great questions, and that's why we're here tonight, to answer these questions. That particular amount that you're talking about, some of the exemptions, and I'll allow it because I think it's a great question. Some of the things that are not the $8 million you're talking about that is included in the project, that's why if you took, and the MSBA was funding this project at 59.17, and you did the math.
Let's do it 60.
As you did it, I was going there next, as you did your checkbook. It's a $60 million project. If they were funding 59.17%, which is 60%, it wouldn't be $30 million each. Some of the cost in the school is not reimbursable, i.e. septic systems.
Correct.
Certain things are not reimbursable. So that's why the 59.1% shrinks to right about a 50% total. That's why you see it's, the total project's 58.4 million, and it's 29 million from the state and 29 million from the town. That's how the figures come up. They add up to that.
Now, how can we be sure that all of this is going to be legal the next time? Is there any way that our state can come in and oversee everything? We are only here as the town of Hanson because of the goodness of the state. The state can step in at any time and take over, A, a school district, B, a town, C, a state for the federal government to step in. You always have a big brother somewhere. Is there anywhere that we can get the state to come in on this in order to make sure that we now have something that will be put out and be allowed to be legal? I'm getting a little tired of this. I have now been here for all these little meetings, including the rally in January. I went to October meeting. Now, if all of these things, all of these rules and regulations that you say are not legal, I'm not a lawyer, obviously. However, if they're not legal, then why doesn't it pertain to everything that the Whitman-Hanson Regional High School School Committee and School District and the meetings that we as voters have held for town meetings since 1985, 82, I'll give you. Why are those declared legal and now all of a sudden they're not declared legal? I'm getting a little bit upset with it, and I just want to make sure that when I take myself out again, I am not going to find that I'm going to be declared illegal because my town officials, and they were town officials who told me, and on Monday following the town meeting, I went up to Ron's office and I spoke with him. No, wait a minute, please.
No, I'd like to answer your question, ma'am, and I understand your frustration. I really do, and I appreciate that. To answer the second part of your question, and we really need to move on, the MSBA is the state. They're the Mass State Building Authority. They are the ones who audit the project. This very building that you are in, they come in and step by step by step, they follow your project totally 100%. It's the very trigger that sent this vote back to where we are today, is because they came and said, this wasn't done properly.
I'm not talking about the MSBA school and the money that they want to give to us. I'm talking about my town meeting that we will be having to hold. Maybe it's not a town meeting, and I shouldn't say that. I want to make sure it's legal by the state.
We will make sure that it is legal by the state. Thank you very much. A couple of good questions. Does anyone have any other questions that we haven't heard answered this evening? Okay, we're going to take a few more. I'm trying to be
Hi, my name is
considerate
Janine.
of your time.
Okay, my name is Janine Foster. I live on Holly Ridge Drive. This is the first time in 35 years that I've ever stepped up in front of a mic at a town meeting.
Congratulations.
Okay,
Thank you.
A little nerve-wracking. If it's my understanding, I read everything about this whole issue. All the articles in the newspapers, all the paraphernalia that had been at the January 25th meeting, which I was a little disappointed because all that information was only pro, nothing written against. Okay? But I read it. I kept everything. If it's my understanding, this particular meeting is only for information, correct?
That's correct. There will be no votes taken about anything to do with the
Okay.
school other than at the bottom of the agenda, the school committee has to vote to have another meeting.
And the purpose of this meeting was to present the legal speak as to the irregularities in the January 25th meeting.
You're totally correct.
Okay. After the results after this meeting is over with, the selectmen will then make a decision on whether or not to, based on the information from the lawyers, they're going to make a decision to either have another town meeting or to bring it up on a ballot, a vote, correct?
Pretty much correct. What has to happen first is the MSBA has to extend the contract in just very nice, easy terms that we already have with them for the school funding. If they agree and they extend the contract, then it comes back to the school committee for a vote whether to move this forward again. Then it would go to the Board of Selectmen, what you're talking about, and they would make a decision whether to have this put on the ballot or whether to have another town meeting. And that is the full 100% process.
Okay.
Mr. Chairman, if I could just jump in, Mark Rich, this end,
sorry.
just a brief correction. The only way that the debt exclusion can be triggered is the ballot vote. So the Board of Selectmen can decide whether or not to go to town meeting, but if the Board of Selectmen chooses not to put the matter on the ballot, then everything is dead, because that is an absolute requirement. There's an option as to whether to go to town meeting. There is really no option about the ballot question. If you don't do the ballot question, the project is not moved.
It's all over.
That's the exclusion.
For the debt exclusion.
The only thing I am asking,
Sure.
okay, is that 50% of this town, 50% has said no. 51% has said yes. From the articles that I have read in the newspaper, I was very disappointed in the way the articles were written up, that they implied that the voters who said no were stupid because inevitably, in the long run, they're going to pay a lot more. That was the impression, that was what I read in the Brockton Enterprise. I found that a little condescending, disrespectful, and insulting, okay? I am asking the school committee and the selectmen, even if it's all legal, what they're saying, even if it is legal, I am asking them to do the ethical thing and present this again to a town meeting and show respect for the 50% of the people that do not want to incur such a large debt in additional taxes. That's what I'm asking.
Okay.
Please consider it.
Can I just answer part of your question? We'll move on to Mr. Vest, because I see him chomping at the bit back there, and I'm okay with that. I don't believe anyone, we as a committee can't control what the Brockton Enterprise or what any newspaper or any of them write. I personally have never been quoted in the paper because one of the reasons I don't get into that is it becomes he said, she said by the writer of the article. So, and I know of no other member on this committee that has done such a thing, to speak negatively or call voters stupid. I have never done that. I think that would be very disrespectful, and I personally know everyone on this committee, and I know that no one on this committee has done that. And that is nothing, we can't control what the media writes. I think you'll agree with that. And I'm not dissing the media. They have to sell newspapers, they have to do what they have to do. But that's not something that's incumbent upon this committee. We have no control over it. Thank you for your questions, they were very relevant. And and you did pretty good for 35 years of never getting to a microphone. Mr. Vest.
Thank you very much. All right, I'll start off with a couple of simple questions. Are both of these schools eligible for reimbursement for specifically demolition, both the Indian Head School and the McQuon School?
Jim, would you like to speak to that? Jim Tuffo? Jim is the chairman of the building committee.
I guess I'd have to understand the basis of the question. If you're talking about in conjunction with the overall project, I would say yes. Individually, as separate projects, they haven't been explored that way.
Okay, so just to clarify myself, that we will be paying for the full demolition responsibilities for both schools?
Yes.
Okay.
No, they're in the
Some part of this is some part of the...
They're not eligible for state reimbursement, we know that.
They're part of the what's the percent? 59.17. But they're part of the $8 million.
No, they're not.
Ineligible?
No, Jim.
Yes. Thank you very much. So we pay for it. Okay, thank you. Second,
did everyone hear, excuse me, Mark, for 1 second, did everyone hear that? Because I was having trouble hearing that. That's the demolition of the buildings is part of the $8 million.
Yes, that is correct.
Okay,
As
I just want everybody, when everybody leaves tonight, Mark?
Wait, that's not true, Bob.
No, I agree. I'm going to let Craig answer that.
Okay, you want to do it, Jim?
No, I just want to give him the sheet.
He can, Mark.
That was the answer, and I want to clarify.
I can take this one. Frank, is the microphone on? Much better. The MSBA allows for certain eligible costs, Mark, and part of the costs in the demolition includes things like asbestos abatement that is not eligible for MSBA reimbursement. The majority of the costs in demolition are eligible for reimbursement, but there are, the way you phrased the question, I think you said is the full demolition of the buildings eligible from MSBA. The full eligibility is not from the MSBA. There are exclusions in that are specific to each building. A large majority of that percentage of cost is, however, eligible.
All right, I'd like to get to my main question. I'll move as quickly as I can. I see there's other speakers. Our group did a lot of work on both of these town meetings. We were responsible for reaching out to the members of the community. We were responsible for making sure that we understood what we needed, the tools that we needed to have in place to achieve the 2/3 vote at town meeting. All of our work was based on the knowledge that this was going to be a 2/3 majority at town meeting. How can you possibly expect us to be content and sit back when you change the rules after the fact? I believe one of the things I heard tonight was letting the vote stand, both town meetings, as majority votes. I'm looking right now at our town council. Is that correct, sir?
You did hear that, yes.
I did hear that, yeah.
You did hear that.
So,
Mark, let him answer. Let him answer.
Yeah. Okay, so subsequently, we worked long and hard hours. We spent thousands of dollars. We had meetings after meetings after meetings, all with the full understanding that a 2/3 majority was required. Would we have changed our strategy if we knew it was a basic majority? Of course we have. Of course it would be. Of course we would have changed our strategy. How can you sit there in all good conscience, ask us to go through this process, of which we beat you not once, but twice, with the rules that were on the table, and then sit back and say, nope, we're going to change it to a simple majority, you lose. It is most unfair. It puts a terrible taste in my mouth, and I'm sure it does for each and every person that went to that town meeting looking for a 2/3 majority.
I have a question, Mr. Best. Because I have a question, and that's a valid point. So I have a question for you. Who told you it was 2/3?
You did.
I did?
It came up at the selectmen's meetings. It came up at the school committee meetings. I heard your own members looking to each other, asking, what is the vote to be taken? And indeed, I heard the words 2/3 majority, sir, from your mouth right there.
I don't believe so, but we
Well,
can
believe
look at
it.
meetings,
It's
'cause
on
I
the
don't know.
tapes.
But I
It's
would,
on the
I would,
tapes.
I would not dispute that.
So I would encourage you.
I mean, I just asked you.
I would encourage you to stop this process right now. You, sir, help them stop this process. Your town council, you can see the damage that your poor homework has done. You cannot change that vote after a town meeting from a 2/3 to a majority vote, because it just throws all our hard work out the window, and it's the only reason you're doing it is try to win this round of this particular question.
Would you gentlemen like to answer that?
Again, Mr. Chairman, I don't know that we have anything else to add. I think we've established that issue already, and now, it's just a matter of again, the matter would go to the voters at an election, and it would be subject to the vote at the election.
Okay. Yes, sir. One more question, and then we will be adjourning this meeting. Oh, I'm sorry. I didn't see you standing there. Go ahead.
My name is Sean Cuniff, 32 Donna Drive. My question is, has the law ever changed? Has the law, regardless of what was told to us in a public forum, has the law at town meeting ever changed that it was more than a majority vote? We're talking here tonight that the voice of the voters has not been heard. In fact, it's been heard twice. Majority has said twice that the voice of this town wants this to pass. Now, that's a moot point at this point, because it does not go to us anymore. I'm a simple chef. I'm not a lawyer. I don't understand all this stuff that you're talking about. But as I understand it, and please correct me if I'm wrong, the town meeting's voice has been heard in a majority twice for this. All is that has won us at this point is for it to go to the town selectmen for a 2/3 vote from them. Is that true?
To put it on the ballot.
And then why everybody, and we were talking earlier, why nobody is here for this? Because they're home with their kids reading them stories right now where they should be, where I should be. But if this is done, we're talking about things that are gone by. We're talking about a law that was amended in the 40s. We're talking about a school that was built in the 60s. My son goes to a school every day where I worry about tiles falling on his
Okay,
head.
but
I understand.
your question is, when was the law changed?
Has the law ever changed from a majority to a 2/3? Whether we were told it wrong or not, that law was the same, correct?
Hasn't changed.
Mark? Jeff?
No, the relevant law with respect to of the process that I'm not sure if we're talking about the debt exclusion. That's, again, the 2/3 vote of the Board of Selectmen. With respect to the incurring of debt, that's the vote taken by the school committee, and the 2/3 vote required of the school committee, and then the simple majority at town meetings. That's the law of the subject.
It's 1949.
Thank you.
Yes, sir.
Chris Howard, Equus Drive. Two very quick questions. One for council, and I think you may have just answered it. As it pertains to Proposition 2.5, I believe it's Chapter 59, 12C, 21C?
21C.
21C. Is there anything within that section of the law that requires a 2/3 vote at town meeting?
Through you, Mr. Chairman.
Go ahead.
Chapter 59, Section 21C doesn't deal with town meeting at all. What Chapter 59, Section 21C says is that if the local appropriating authority seeks a debt exclusion, so again, that's your Board of Selectmen, the Board of Selectmen would have to vote as a 2/3 majority to put the matter before the voters at a ballot at a town election, and a town election is a simple majority.
And so to follow up on that, the local authority is defined as the Board of Selectmen,
Yes.
not town meeting.
It's a variation from the norm. Ordinarily, as we know it, budgets and appropriations are voted by town meeting. Under Chapter 59, Section 21C, the definition is very clear. That's your Board of Selectmen.
And my second very quick question, and I leave this open to the school committee here, building off the point from the last gentleman. Again, we've had 2 town meetings where a majority of the townsfolk have spoken that they want this to go to a ballot. My open question to all of you to think about is, why would you not put this to a ballot and let the town speak?
Mr. Young.
Thank you very much, Mr. Hayes, and thank everybody for their patience this evening, and the attorneys for their patience as well. It's been a tough meeting. There's been a lot of emotions shown.
Yes, it has.
Both ways, and I appreciate everybody's patience tonight.
Thank you.
I just want to correct one thing that you just said. Department of Revenue, Department of Revenue, Division of Local Services, Technical Assistance Bureau, Chapter 21C, raises additional tax revenue to pay debt service costs to finance capital projects. It requires a 2/3 vote of town meeting, town council, or city council, or the additional property taxes are not permanent, but are removed from the levy when the term of the bond ends. Okay, I just wanted to correct them on that. Because debt exclusion questions at town meeting under Chapter 21C require, and have always required, a 2/3 vote at town meeting. And may I add to this, okay? If they were wrong twice, okay, and I was on the Board of Selectmen, I just want to make this comment, because I was on the Board of Selectmen that hired this prestigious law firm. We used to have local attorneys before that, and I discussed it with Jeff, and we had a good conversation about it. So they've been representing us since 1985, around 1985, 86. And for the most part, they've done a good job. And I want to tell you that every school issue that's come up since they've been the attorneys, every school issue regarding borrowing has never required it to be under Chapter 71, section, what's the section of the law?
16.
71, 16D and 16N. Those have never applied. And we've always had a 2/3 vote, not only for these last 2 votes, but for every vote requiring school funding by borrowing by the Whitman-Hanson School District, going back to 1985, ladies and gentlemen. So if they were wrong twice, they were wrong on the regional school, they were wrong on the middle school, they were wrong on the renovations to the Indian Head School, they were wrong on the feasibility study, they were wrong on the renovations to the McQuan School.
Bruce,
Does
do you
that
have a
make any
question?
sense to anybody in this hall? Does that make any sense to any of you?
Mr. Chairman.
But Bruce, do you have any questions?
It took him, and I want to say just one more thing, and then I'll close it. I have one more thing to say.
You have a question?
Yes, I have a question.
Thank you.
Yes. And I just want to ask the town attorneys this. The vote on the 25th and on the 7th have been certified by the town clerk. And the town clerk told me this today. I says, what's the procedure from there? From there, she sends those certified copies of the vote. And not only the certified copies of the vote, but I asked her this. The certified copies of the way the vote was taken also go in so that the Mass Department of Revenue can see those and certify those as well? And is that the way the town clerks have always handled it? Yes. So what I just said was, and you can comment on this, all of those votes going back to 1985 have not only been certified by the clerk, but have been certified by the Mass Department of Revenue to not only make sure they were worded correctly, but to make sure the votes were taken correctly. So what you're saying is every one of those votes that have been certified going back to 1985 by the DOR was wrong, and you were wrong. Is that what you're trying to say tonight?
Mr. Chairman.
Yes, go ahead, Matt.
I do appreciate this is a very long night, and...
I've got to take two more, and then we're going to be done.
And no, we would stay all night as necessary, regardless of what kind of comments come our way. We are here to answer whatever questions are necessary. But I do think it's important to clarify, Mr. Young and I had a very lengthy discussion about that Department of Revenue bulletin, and I tried very hard to explain to Mr. Young that he's misreading that bulletin. A borrowing by the town would require a 2/3 vote of the town meeting. This is not a borrowing by the town. That is why to read so narrowly the Department of Revenue bulletin is to read it wrong. That borrowing, the reference in that bulletin has to do with a borrowing by the town, which would in fact require a 2/3 vote, and then the debt exclusion would require a majority vote at the ballot. In this case, because it's not a borrowing by the town, it's not a 2/3 vote. I'm not going to answer to the other votes because I don't have any of that information in front of me, and I don't think it's relevant to tonight, and I'm certainly not saying that anything that was done previously was wrong. I'm just answering that one question, Mr. Chairman.
Thank you. Ron.
Thank you. Thank you. Just to be clear, there's about 100 people in this room holding a packet of information that I gave out tonight. And I wish I had my copy, but because we didn't have enough copies, I gave it to the staff to make a copy for it. You will find in that packet no, this is not the right one. There's a packet that has an opinion from the State Department of Revenue Services. You will find that I specifically, in lieu of the problems, asked the Department of Revenue Services to give me an opinion on this issue, and that opinion is enclosed in that packet that you have. What the State Department of Revenue Services says specifically that as it relates to a regional school district, a simple majority vote is required. As it relates to issuing of debt, it's a 2/3 requirement. So you will see, I'm not asking you to believe what the attorneys have said tonight. There's a letter in there from a specific gentleman at the State Department of Revenue Services that you can call. His information is in that packet. You will see the written opinion. It's not specifically for Hanson, because the opinion was written for another town with the exact same problem and the same question was asked. So frankly, if you don't believe anyone up here, please read that decision. Please call the State Department of Revenue Services and you will find that they will give you the same opinion. For a regional school district, it simply requires a majority vote. And I know it for sure because I've asked them twice. The first time I asked them was at the beginning of this process, where they told me just the opposite. They said a 2/3 vote was required. Now you might ask why that is. Well, it's simple. When I asked them, I didn't say to them that we're in a regional school district. So they gave me an answer on a single school district and said a 2/3 required. Once this all occurred, I asked them for a legal written opinion where they went at great lengths to explain to me that it's different under a regional school district, and you folks can get that question answered directly through the State Department of Revenue Services Local Services Division, and they will answer the same way they did me.
Joe?
Mr. Chairman, thank you. Joseph Campbell, 150 Woodbine Ave. We were notified to come here tonight to hear about a mistake and to move forward.
That's correct.
We came together for the board to hear a collective think tank that they asked the citizens to come and be a part of, to address a serious issue. All I've heard tonight is degradation and indignity, and I'd really like that to stop.
Do you have a question?
I do. The question I have is, regardless of what happens here tonight, does the school board plan to have some kind of a committee that will come together for opposition and pro to come together for that think tank that you're looking for here tonight? I think that you were hoping to hear some of those things aside from all the stuff that's happened in the past that some people are wanting to dwell on. Is there some kind of subcommittee that the school board's going to be asking for those that want to move forward to come together?
Yes, Joe.
Thank you.
As I explained the procedure earlier, we will be waiting for a response from MSBA to see if we're extending the agreement of the funding. If that comes in the affirmative, the school committee will be holding a school committee meeting which is an open meeting. They've been open for as long as I know, and they've been open for 30, 40, 50 years before that. Same as building committee meetings. They are open meetings. You will be able to come, reiterate what you want to talk about, and then sit there and watch how your committee votes so you will know exactly what happened. That will be one more step in the process of trying, whether you're for or against, if you want to put it that way, it was your terms, whether you're an opponent or proponent of that, you will be able to come and state your case, and then this committee will be taking a vote. If this committee votes in the affirmative, it will go to the selectmen. If it votes in the negative, it's done. It's null and void, it's over, okay? Does anyone have any, I know Mr. O'Sullivan's been patiently waiting for me to look at him, but does that answer your question? Joe? Mark, Joe's been standing up there.
I know, let him go.
Hi, Joe O'Sullivan, 625 West Washington Street. And without launching into dueling law sections, Bruce quoted Section J, but Section I and a half of the same law clearly states local appropriating authority, any seat of town by 2/3 seek voter approval, a regular special election to assess taxes in excesses of the amount allowed pursuant. It's basically what the attorneys have said. It's Section I and a half after Bruce's Section J. So I would support that one. In terms of, I worked very hard for the town meeting to support the schools, because I think it clearly is the best and most cost-effective direction this town can go. And I think giving back $29 million to the state would be obscene. However, to think that I would have worked less hard to get people there if I knew it was a simple majority is ludicrous. Both proponents and opponents had valid rationale for this thing. We both worked very hard, and the majority of the people in this town have supported this twice. I've never been comfortable with 1/3 of the people making a decision for everybody who lives in the town. And that's what the people bought under Proposition 2.5, and it put this town into a tailspin. We had kids walking to school in the 90s because we eliminated busing because of Proposition 2.5. And then when we voted to a debt exclusion to get the busing, the next year the selectmen used it for something else. So I suspect if the worst thing that comes out of this is to go to a ballot, why not?
I was just getting ready to ask you, Mr. O'Sullivan, if you had a question. As you can see, ladies and gentlemen, I have given everyone plenty of leeway this evening because I think this school system, this big debt that you're talking about, needs this type of latitude. So I apologize for keeping you to this late hour, and I have let everyone speak.
Point of
have some
information, Mr.
latitude.
Moderator.
Yes, Mr. Vest.
New information be presented, please.
It is new information.
All right, briefly.
Thank you.
Briefly.
Thank you.
I would like to announce that 2 recall petitions have been pulled at town meeting.
Is that a question for this committee?
Members of the Board of Selectmen.
Is that a question, Mr. Vest? We're not here to make statements, we're here to make questions. That, you're out of order, but thank you. The last question.
How many of you have been involved in building for anybody else?
Town of Hanson, let's stick to our guns. Go.
2 people.
All of you.
Okay.
And you've all
You're,
tonight, it all made sense, and I wish you all luck. And you don't get a real estate like I get every 3 months for $1,875. I'm house poor. Don't let it happen to you. Bye now.
Thank you. Okay, this is the last question. You have a question, sir, I'm sure of it.
ladies first. So you're voting on a project of a large magnitude, and it's a huge undertaking.
That's true.
And as you go along, the questions get faster and faster and faster, and they come at you quicker and quicker. There's a lot of decisions that have to be made. to make this thing come out right. And I hope you understand the magnitude. I think the superintendent of the schools quit after he built the high school, didn't he?
No.
Didn't he move on?
He retired.
I thought he was exhausted.
He retired.
I think he retired out of exhaustion, didn't he? It was took a lot out of him.
It definitely was a ton of work.
Yeah.
And you can see the fruits of his labor. You're sitting there in them.
So I've been involved in manufacturing and building buildings and houses and whatnot through the years. And sometimes it's tough to get your hands around. But I never see new as a measure of good. You know what you got, you know what you got. New is an unknown. Always an unknown. Now, if you don't believe me, take a look up to UMass Amherst. The big tower coming out of the valley is a library. Guess what?
Was your question,
They got to come up with the, factor in the weight of the books for the library. So, anyway, I just wanted to comment on new was not again a measure of good. Now, if the Article 1 is to see if the town will approve the $58 million and change borrowing authority, or the borrowing authority of the Whitman-Hanson Regional School District, the district, for the purpose of paying the costs. So what was the misunderstanding there? I mean, to me, it's the district. And it's very clear that it was the district.
What's your question?
So how do we end up not going along with following the correct format? Because it states in here that it's a district.
Mark, would you like to answer that for me, please? He's going to explain that to you, and that will be the last question.
Well, what was happening was, although it was, you're right, it does say the district, for all intents and purposes, it was the town of Hanson doing the borrowing. So we looked at it, I mistakenly looked at it as a town of Hanson borrowing, not the district. And that's where, because in reality, that's what it is. Under the agreement, it's the town that's on the hook for everything. The town of Whitman isn't on the hook for any of the monies. So that's what the way I looked at it as, a town of Hanson borrowing. And that's the problem.
It's very clear. It's very clear.
And I know that, and you know, of course.
In the first sentence, it says, borrowing authorized by the Whitman-Hanson School District. The district.
Sir, I've read it. Believe me, I've read it more times in the last week than you'll ever know. I understand that now. You asked me how the mistake was made. I explained to you how the mistake was made. That's, you know, I'm human.
Thank you very much. Ladies and gentlemen, thank you for your patience. I hope that you come away with some sort of a idea of what is the total project here. I thank you all for coming. The school committee has to take one vote, then I will be entertaining a motion to adjourn. I'd entertain a motion. Made by Fred Small, second. Seconded by Bob Trotter. Any further discussion? All those in favor? Opposed? Unanimous? Thank you. I would entertain a motion to adjourn. Made by Fred Small. Second. Kevin Lynham. Any discussion? All those in favor? Thank you. Thank you, ladies and gentlemen. Thank you for your patience.